My lords, may I pray for your lordship's leave to mention a very urgent contempt and miscellaneous application?
Yes.
Lordships had on the 9th of April passed an order directing status quo to be maintained with regard to a diagnostic center that had been sent up, my lord, in conjunction with the state. My lord, that order has been flouted with impunity. All my equipment have been removed. I don't know to what destination. And my lord, there's massive construction work that is being undertaken. My lord, I have, my lord, filed the applications today. If your lordship permits it to be listed and allows me to move it, my lord, virtually tomorrow, I'll be very grateful. I am very grateful. Very grateful.
To be listed and to be moved virtually.
I am very grateful.
Mr. Shah, it will be better if you serve notice on the respondent.
I will do that immediately.
Yes. And serve a copy on them.
Yes. It's notice and copy.
Item number 1.
My lord, this is come at my instance, my lord.
Yes. Yes,
the public
what would be the convenient date for you?
My lord, 7th, 8th and 9th I was praying for in the other matter, which Mr. Shah is appearing. So any of those dates it will come on the 7th or the 8th. It will be basically, today only for fixing a date. So on that day, we can make submissions for direct.
Are appearing in this matter?
No, well, not in this matter.
No, but I have informed everybody, my lord, to this.
My lord was my lord, suggesting that 7th, 8th and 9th be kept for his arguments in the other matter.
Yes.
But I have no difficulty. Only your lordship will allow me to, my lord, join because I have no submissions to make on those days to join lordship.
So if your lordship keeps this on the 7th or the 8th, whichever date your lordship fixes. On that date, your lordship may take up the matter, but today is only for fixing of dates.
My lord, as per the last order, my lord, inquiry was directed to be conducted, my lord. The inquiry is still going on, my lord. We also need some time, my lord.
So the matter was scheduled to be listed on 7th March.
7th of April, so it's
7th
already.
April.
So let it come.
Holiday, so we are just
Yes, my lord.
extending the returnable date to.
So let it come on the 7th, my lord.
Let it be on 8th, lordship. I am appealing.
Very late, my learned friend, this is for one of the party, 8th.
This public interest litigation was scheduled to be listed on 7th April. Next, that day was declared to be a state and high court holiday subsequent to the order. This writ petition was mentioned by Mr. Deval Kumar Banerjee, learned senior advocate, appearing
Or respondent 9.
for the respondent number 9 to refix the returnable date. Accordingly, we direct this petition to be listed on 8th May 2025. Advocate on record for the respondent number 9 will give notice to the non-appearing respondents, if any.
I believe they are here, my lord, but state is here with petitioners.
Any non-appearing,
They're all here, I think.
any non-appearing party, if any.
Obliged.
Number 2.
All right. Pass over for 5 minutes. For the next person.
Number 3 and 4.
Those 3 and 4. Ready for hearing?
Lordship.
All right. Pass over. Next.
Item number 5.
May it please your lordship.
Yes.
Lordship, in compliance with the lordship's order dated 18/3/2025, we have already filed a supplementary paper book. Senior counsel has some personal difficulty today. So, senior counsel Mr. Kiran Chaudhary, he travels from Guwahati, my lord. He has some personal difficulty today, subject to your lord.
You are for the appellant.
I'm for the appellant, my lord.
What do you say? Yes. When, please agree on a date. When?
5th of March, 5th of May, my lord.
Supplementary paper book filed.
Yes, my lord, it's fine.
The appellant's advocate on record has filed the supplementary paper book and served a copy thereof on the respondent's advocate on record. By consent of learned counsel for the parties, list this appeal on 5th May.
Number 6.
But list these appeals. Who's in 6?
Item number 6.
Your Lordships, I pray that this matter be taken up tomorrow as the conducting counsel is not available today
You are for the?
for the appellant.
Tomorrow would not be very convenient for me, your lordships.
Then 29th.
29th.
On the prayer of learned counsel for the appellant. Comma. Not opposed by learned counsel for the respondents. Comma. These appeals are adjourned till 29th April. Yes, carry on.
Number 7.
Milord, if this matter can come up sometime next week, Milord.
Yes. April
30th.
by consent of learned counsel for the parties, these writ petitions are adjourned till 30th April.
Upright.
Number 8.
Yes, please.
Madam, in this matter, Lordship issued notice to the waitlisted candidate number 2, my lord. This is particular, Lordship recollects pertaining to recruitment in Nigrim's Medical College, my lord.
Yes.
The respondent was one of the waitlisted candidates. She was at number 2, my lord, in the waitlist. And waitlist number 1 did not oppose this honorable court, my lord. And now there is one vacancy. So Lordship issued a notice to the waitlisted candidate number 1. I believe he is here.
Ask him whether he is interested in the appointment or not.
Are you interested in this post? You join somewhere else. Common post. So he has got another employment, my lord. He is not interested.
DERT, Directorate of Research,
Education Research in state government, my lord.
But her client is waitlist number 2.
We listed number 2, yes, your lordship.
So the vacancy can be filled up by appointment of waitlist number 2.
My
Hmm?
lord. So, my lord, what I pray is the matter comes up tomorrow or day after tomorrow, my lord.
Again, why? Again, you will seek instructions.
Your lordship, may I submit, your lordship? Prior to them giving appointment to the candidates on the second advertisement, your lordship, there is a stay order, your lordship, in my favor by the single bench, your lordship.
My lord,
That has not been
my
complied
lord,
with.
can be disposed of, my lord. Since waitlisted candidate number 1 is not interested, my lord, waitlisted candidate number 2,
But you have already started a fresh selection process.
my lord, that is complete, my lord. So, because there were subsequent vacancies, those have been filled up. So one vacancy is still there, my lord, where she can be accommodated. My lord, I have only 2 submissions to make, my lord. Number 1, the learned single judge is directed for her appointment with retrospective effect, my lord, if I may take your lord. So my humble submission needs to be rectified, my lord. Prospective, my lord. And
Your Lordship, as per the office memorandum, Your Lordship, I'm supposed to be filled
You are
immediately.
supposed to, but don't delay the benefit your client is getting. You are getting now one bird in hand is worth 10 in the bush.
Your
Don't try
Lordship,
to argue the matter and delay, and then they will prefer an appeal to the Supreme Court and everything will
I
be.
understand, Your Lordship.
Yes.
Yes, I understand that, Your Lordship. But then, second thing, Your Lordship, the promotion, my promotion will also be affected, Your Lordship. Because as per the office memorandum, I'm supposed to be
Then
filled.
you fight out the matter.
And second aspect, my lord, the learned single judge imposed a cost of 50,000 rupees, my lord.
Huh?
Learned single judge imposed a cost of 50,000 rupees, my lord. That may kindly be waived, my lord.
Your Lordship, the cause is towards the contempt towards the interim order, Your Lordship.
You go on like this for 10 years, you will get nothing. The matter will travel up to the Supreme Court. You go on.
Lordship,
Is that
in
a
that
great,
case, and I,
great benefit you will reach your client. He is getting an appointment today, you are saying no. Give me retrospective.
Your Lordship, I withdraw my.
I will be deprived of promotion. Keep on fighting.
Your Lordship, I withdraw my submission, Your Lordship, but at least the cause, I am objecting towards the.
All right, you come on. You please get up your mind and come on Tuesday.
All right, I'll take instructions.
List this appeal and the miscellaneous application on 29th. Full stop. It is recorded that further to our earlier order, the waitlisted candidate number 1 in the subject selection process is present in court and states that he is not willing to accept any appointment under this selection process, as he has found employment elsewhere.
Madam.
Okay. Call the past over.
Second call, item number 2.
I'll be obliged.
Yes.
May it please your lordship. Lordship, this is a appeal against the
Limitation is the point.
lordship. Yes, I'll thrust a million limitation, your lordship.
Yes.
May it please your lordship. Lordship, this is an appeal against the judgment and decree dated 24/5/2023, passed by the Learned Commercial Code, your lordship, in commercial suit number 1 of
You have already argued in part this appeal.
lordship, yes.
Yes.
If lordship kindly come to page 9 of the memo of appeal, your lord. The admitted fact, your lordship, is that the cause of action or for the suit arose on 6/4/2005 and then 2007 and 2008, your lordship. This is the pleaded case of the respondent plaintiff before the learned trial court, Your Lordship. It is also the admitted fact, Your Lordship, that the construction, Your Lordship, has been completed in the year 2008. In the year 2008 itself, Your Lordship, is the respondent plaintiff here in Your Lordship is demanded the payment of the bill. No response, Your Lordship, and he waited, Your Lordship, for 3 years. In 2011, Your Lordship, he issued a notice by a council, Your Lordship. If Lordship can come to page 173 of the paper book. If Lordship kindly come to second paragraph from the bottom, that after execution and completion of the work project, your concerned department has not completed my client final bill, which is causing undue financial hardship to my client after a gap of more than 3 years, Your Lordship. Then, Lordship, he did not do anything. In 2012, Your Lordship, page 178 of the paper book, Your Lordship,
For what already?
page 178, Your Lordship. Your Lordship, the typed copy is at page 179. Lordship, kindly see. This is the letter issued by the respondent plaintiff, Your Lordship. Lordship, it says like this: in inviting a reference in your kind attention and to the subject above, and to inform you that I have been allotted the above mentioned work from CR and the department as per work order enclosed. I have completed and handed over the building during the March 2008. That is the admitted fact. In spite of my repeated reminders, it is with great regret to inform you that the final bill has not been reimbursed. Then, Your Lordship, nothing has been done, Your Lordship. Then in 2013, Your Lordship, kindly come to page 180, Your Lordship. He demands the final payment of the bill, Your Lordship. Then in 2014, Your Lordship, page 185, Your Lordship. The typed copy, Your Lordship, at page 186. Then, Lordship, finally, Your Lordship, in the year 2015, he issued a legal notice, Your Lordship, that is at page 190, Your Lordship. This is the legal this is the notice under section 80 of the CPC, Your Lordship. And it was replied, Your Lordship, by the authority, Your Lordship, at page 192, Your Lordship. If I take, Your Lordship, to page 193, Your Lordship, at para 5 of that reply, Your Lordship. Denied, as per the records available, the department has not revised the estimate of 1,07,03,200. Your client has received 69,97,704 only out of the estimate cost of 78 lakhs. Therefore, he is entitled to be paid the balance amount of rupees so and so only after the completion of the work minus penalty to be imposed upon him due to the delay in completion of the work. However, copy so and so. So, Your Lordship, when notice, then again, Your Lordship, he filed a writ petition. Your Lordship, he filed a writ petition before this honorable court, Your Lordship. That also has been rejected, Your Lordship. Then subsequently, he filed a suit, claiming for recovery of 1,07,03,265, Your Lordship. The state did not file a written statement, Your Lordship. It went ex parte, Your Lordship. The state filed an application, Your Lordship, for recalling that, and, Your Lordship, the Honorable Court, Your Lordship, the trial court, Your Lordship, allowed the state to participate in the proceeding, Your Lordship. That means the respondent plaintiff was subjected to cross-examination, Your Lordship. That I'll also refer, Your Lordship, his deposition before the learned trial court. Two issues, Your Lordship, have been framed, Your Lordship. If Lordship can come to page 201, Your Lordship.
What has the learned trial judge held?
Lordship, the learned trial judge took that from the date of issuing the legal the notice under Section 80, that would be the cause of action, Your Lordship. Which, in my humble and respectful submission, Your Lordship, is not really sustainable in view of the fact that it is the pleaded case of the respondent plaintiff.
What is the page of the decree?
Lordship, kindly come to page. Lordship, the fact of the case has been discussed by the landed trial court at page 204, Your Lordship.
Date of the decree?
The date of decree, Your Lordship, is 24/5, Your Lordship.
24?
24/5/23. Lordship will find it at page 231. 231, Your Lordship. Lordship, the issue framed by the learned trial court, Your Lordship, if Lordship kindly come to page 218, that the issue number 2. Whether the issue number 2, Your Lordship, whether the instant suit is barred by limitation. The plaintiff has filed the instant suit for recovery of a sum of rupees so and so only. It is the pleaded case of the plaintiff that he completed the contract work on 31/3/2008, but even after the building was handed over as to them as far back as on 31/3, but no payment was made to the plaintiff, not the revised estimate approved by the government. The revised estimate was never approved by the government. He submitted in the year 2007, Your Lordship. It was never approved by the government. The plaintiff, during evidence, accepted copy of the letter so-and-so, as paper mark so-and-so, was submitted to the block so-and-so. It is further the case of the plaintiff that by letter dated so-and-so, the defendant number 3 asked the block development officer, Kambikri Community and Rural Development, West Carroll, to take possession and issued a certificate handing over the building to the department. His satisfaction over the workmanship. The letter was exhibited as Exhibit 7 and the protocol is marked as paper 6. It is the case of the plaintiff that officer on special duties also, by his letter dated informed that the defendant number 3 has been asked to submit the revised estimate of the project. The plaintiff during the exhibited the letter dated so and so. It is for the plaintiff case that it was only on 9/9/2014 by letter informed the deputy so and so that he had submitted the revised estimate to the officer on special duty so and so for approval after site inspection by the it is for the pleaded by the plaintiff that he issued a pleader notice dated 18/2/2015 highlighting his grievances and requested for release of the pending bill, and in response to the defendant number 2 by letter so and so addressed committee that the tender value was never revised and that the plaintiff is entitled to 9,85,096 only. It is maybe stated that in normal course, as per Article 18 of the Limitation Act 1960, the period of limitation.
Yes, we have seen it.
Lordship, yes.
What do you say? It's hopelessly barred.
If Lordship, the learned in my humble and respectful speaking, has not referred to Lordship kindly. Article 18, your Lordship.
All right, we know all that. Article 18.
Lordship, yes. It is from the date of completion, your Lordship. So here, your Lordship, the date of completion is 2008, your Lordship. That is the admitted fact.
No, date of 18 is regarding acknowledgement. Acknowledgement of wealth.
Lordship, 2008, Lordship.
Yes. How do you support your claim?
My Lord, the cause of action arose on the day when the notice was replied by the government, stating that I am entitled to only 10 lakh rupees from the bill and 5 lakhs for security money, my Lord. So from that day, for so many years, they kept hanging that amount also, which they admitted that I am entitled to. It was not paid. Finally, they say, yes, you are entitled to only this much. So not from the date of handing over, but from the date they replied that I am not entitled. So there was no other option but to go to court, my Lord. And one more point, my learned friend has referred to almost all the registers here, but my Lord, kindly come to page 187, my Lord, of the paper book. In which they have admitted that I have done extra work. Page 187 of the paper book.
Whatever you have done.
Yes, my Lord.
It was over in 2007, 2008.
Yes.
Now, for whatever you thought you deserved, you should have billed or claimed within 3 years therefrom.
It was claimed, my Lord. That is why I am something, my Lord. If my Lord can come to page 187, it is a letter written by them that yes, I am entitled to revised estimate, my Lord.
The suit should have been filed within 3 years.
But from the date of rejection of my claim, my Lord, so long they did not reply to my letter.
Not
only on that day it was
from the
replied.
date of accrual of cause of action.
No, my Lord, when in this letter also that I am referring, my Lord, at page 187, they have acknowledged that I have done the work. Then what prevented them from
Where is that?
page 187, my Lord, of the paper book? So that submission, when I found that 2008, it was over. No. But let me read it. Sir, with reference to the above, I have the honor to bring to your kind attention that the revised estimate of the scheme being prepared by the concerned block development officer and has been submitted to the officer of special duty technical CNRD Meghalaya, Shillong, while later this dated 9/8/2013 for approval after site inspection, but undersigned revision of the estimate may perhaps become necessary as the respective contractors have every now and then complained that their unpaid amount through their written letters. So in the year 2014, they acknowledged that yes, I am entitled to the bills for extra work.
Where? Nothing. There is no such admission.
And it has written to the government that yes, you please accept it. It is the estimate should be accepted by the government. The officer who is there, block deployment officer, he is saying that I have carried out the work. On site inspection, this report was made, my Lord. And my lord, what the learned trial court has said, it said that whatever the remaining amount you admit, you pay and release the security money, as well as you go for revision and calculation of the revised work. There is no such direction that you pay this much on account of revision that they have come in appeal, my lord. There is no appealable order. It is only direction to the government to calculate. If they find it, I am not entitled, then it finish. Let us finish there. The ball is in their court, my lord. So what the court can do in this, in that order? Had it been like that, you have to pay the entire amount as claimed by me, my lord. Yes, they could have filed an appeal if it had it been accepted. But it is not accepted by the trial court. Trial court said that it's all right, let them calculate whatever I am entitled to.
The Limitation Act.
And my lord, I am denying a citation of the Supreme Court, my lord. That from which day the limitation will start running, my lord. नहीं से है तो this judgment which I am citing is exactly the same situation developed there, my lord. This is 2018-12 SCC 393.
This one?
Yes, my lord. From page number 7, paragraph number 9, my lord. The relevant portion is there. So far as the fact is here, my lord, but from paragraph 9 to 10, it speaks about the Article 18 of the Limitation Act 1963 provide for filing of a suit for recovery of money for work done by the plaintiff within 3 years from the date when the work is done, as my learned friend has submitted. In a situation where no time has been fixed for payment, Article 55 of the Limitation Act 1963, on the other hand, provides for limitation of 3 years from the date of breach of contract. In the case of a suit for compensation for damages arising out of such breach, Article 113 of the Limitation Act 1963 is the residuary provision which provides for a suit to be instituted within 3 years from the date when the right to sue accrues. In the present case, dehorsed the correspondences that had been exchanged between the parties after the date of final payment, that is 13 January 1981, the aforesaid date of final payment would have been crucial for determination of the period of limitation for filing the instant suit. However, in the present case, from the correspondences that had been exchanged after the date of final payment, it clearly appears that the plaintiff, after receipt of the payment of 13 January 81, reiterated its claim for additional payment on different counts, including escalation and for extra work done. The defendant, instead of rejecting the said claim, entertained the same and kept the matter pending. Finally, on 6 November 81, the said claim were rejected. If the claims raised by the plaintiff were entertained and rejected finally on 6 November 1981, it would be reasonable to assume that the cause of action for the suit in respect of the said rejected claims arose on 6 November 1981, and the suit could have been filed at any point of time prior to the expiry of 3 years from the said date, that is 6 November 1981. In view of Article 113 of the Limitation Act, the suit having been filed on 6 November 1984, the same therefore will have to be considered to be within the period of limitation. The High Court therefore was not justified in holding the contrary. This will require the court to consider the additional plea as on behalf of the plaintiff, namely, that the High Court was not justified in reversing the decree passed by the trial court so far as 50% of the escalation charges is concerned. The High Court is coming to the aforesaid conclusion, took the view that the specific clause in the agreement which obliges the plaintiff to continue to offer his rate for the entire duration of the contract prohibits grant of the said claim. We have also noticed that it is the defendant's own case that it was responsible for the delay to the extent of 19.5 months that had occurred in the execution of the contract, whereas the plaintiff was responsible for the delay of the remaining 15.5 months. The said specific admission on the part of the defendant and the finding arrived at by the High Court on the aforesaid basis could not have permitted the High Court to reverse the decree passed by the trial court on the aforesaid count, which incidentally entitled the plaintiff to only 50% of the escalation charges as claimed. The aforesaid percentage roughly corresponds to the percentage of the delay attributable to the plaintiff out of the total delay of 35 months. The clause in a contract which obliges the plaintiff to continue to
You consider this case and come back.
Yes,
With from rejection of the revised claim.
Lordship, in
Limitation.
fact, if Lordship allowed me, I'll place one recent decision of the Honorable Supreme Court, Your Lordship.
No,
It
you
was exactly on the
no, but this is exactly on this point.
Lordship. This case also is exactly on my argument, Your Lordship. If Lordship.
When was your claim rejected?
In 2015, Your Lordship, when he submitted its
date. Where the reply was made to my legal notice.
15/4/2014, Your Lordship. That is the legal notice, Your Lordship. Legal notice of 2015, Your Lordship, and the reply dated 15/4/2014, Your Lordship.
Reply was given on 15/4/2015, rejecting my claim, my lord. On 15/4/2015, page 220, last of the paper book and the last line, my lord. Last
And your claim, additional claim?
Of 9,85,096, which is the remaining portion of the bill, my lord. But so far as the additional claim is concerned, it has just asked them to calculate. That is the only thing they have done. No order has been passed on the additional claim.
If Lordship kindly done judgment, Your Lordship, Nikhila Divyang Mehta versus Hitesh P. Sangvi. Lordship kindly come to para 24 of that judgment. There is no dispute to the fact that the limitation of filing of the suit fall under Article 58 of the Schedule to the Act, wherein the limitation prescribed is 3 years. It may be pertinent to note that the limitation of 3 years is the date from the cause of action first arose. So according to the plaintiff case, the cause of action first arose on so and so, and therefore the limitation would end on so and so. Lordship, as I have submitted, Your Lordship, the case of the respondent plaintiff, Your Lordship, as pleaded in the plain, Your Lordship, that the cause of action arose, Lordship, first in 2005, then 2008, Your Lordship. However, if the limitation is called from the date so and so, it would run for the first week and would and in wherein the suit admittedly was incident on so and so much beyond the first and asserted but by limitation, for which neither any defense is required to be looked into nor any evidence in support is. Section 3 of the Act contemplates that every suit instituted after the period prescribed under the Act shall be dismissed even if limitation has not been set up as a defense. The aforesaid provision is of a mandatory nature and cannot be ignored by the court even if it is not pleaded or accused by the defendant. It is obligatory upon the court to dismiss the suit if it is on the face of it barred by limitation. The aforesaid provision has been enacted for public courts and to keep quietus to the remedy after lapse of a particular period as the matter of public policy, though throughout extinguishing the right in certain cases. Therefore, once a limitation prescribed, for instance, this cause of action expire, and if limitation is not set up as a defense, it obliges the court to dismiss the suit as barred by the limitation. In the present case, the plaintiff not only categorically state that he acquired knowledge of the will and the codicil in the first week of November, but also the cause of action for the suit arose on 4/2/2014, and lastly, and so this was filed on 21/11/2015. Exactly, in my humble and respectful submission, Your Lordship, exactly the case, my case, Your Lordship. 2005, the pleaded case, 2008, Your Lordship, that is the cause of action, Your Lordship, and the suit was filed in the year 2016, Your Lordship, after a period of 8 years, Your Lordship.
No, there is no question of consideration of revision of the bill and taking a decision.
Lordship, as I've submitted, Lordship, that the revision of the bill, Lordship, was never approved, Your Lordship. So there is no question, Your Lordship, of considering, Your Lordship.
Maybe not question, but the Supreme Court has allowed the date of rejection of the application for revision of the bill to be the accrual of
Lordship,
other.
can you see of the sequence, Your Lordship? As I've submitted, Your Lordship,
We know all this. So we have to consider, we are being at CAB. You want to make any further arguments?
Lordship, my humble and respectful submission, Your Lordship.
You file your notes.
Lordship.
Would you like to make any further arguments?
Lordship, that's all, Your Lordship.
Then anything else you incorporate in your notes? Written notes?
Lordship, I'll do that. I'll do that.
Hearing concluded, CAB. Advocate on record for the parties are at liberty to file written submissions before the courtmaster attached to this court. By 7th May.
7 May, Your Lord. Highly applied.
You just call in for 1 minute with the counsel.
I'm sorry about that.
You are not making any submissions on the merits.
Lordship, on merits also I'll file, Your Lordship, because Lordship can, if Lordship.
No, the merits, you have nothing to say on the merits, your only point is limitation.
Lordship, I also would like to work on merits also. Merits, Lordship, can you see, Lordship, as I've submitted, there is no revision. That hasn't been approved, Your Lordship. The learned trial court or not to have directed, Your Lordship. Lordship, if Lordship, can you have a look at the impingement?
Then don't close your arguments. Why are you closing your arguments? You argue on merits also.
Lordship, yes. Lordship, if Lordship, can you have a look at the impingement judgment passed by the learned?
Learned counsel for the parties have made and concluded their argument on the point of limitation. List is appeal for further hearing on merits. On 30th April.
30th April, you know.
30th April.
Lordship. Hello.
Let's call the fixed matter.
Item number 9 and 10.
You cited 5 cases, Mr. Shah.
Yes, my lord.
The last being 71-3
That's it. Now, my lord, I will quickly, my lord, just cite 3 more judgments, which are, my lord, more pertinently on the point. And, my lord, I shall conclude my submissions with a brief summary. But, my lord, may I just tell you, lordship, pricing is, my lord, one of the facets of arbitrariness. Because, my lord, there is no regimen, no control, no checks and balances on the pricing. This apart, my lord, this disturbs the market equilibrium altogether. Initially, my lord, there was free play in the market. Because, my lord, whenever there was a demand at site that would translate into a demand in the hands of the bonded warehouses, who would, my lord, then order directly from the distillers, bottlers. But, my lord, that equilibrium is totally destroyed today. And, my lord, our challenge is the, my lord, constitutional challenge. I've already shown you, lordship, Article 19(6), and how it, my lord, says that only a monopoly in the hands of the state can be created, nothing else. Now, my lord, may I show you, lordship, now, my lord, the judgment of, my lord, the Uttarakhand High Court in the matter of, my lord, United Spirits Limited, my lord, where similar questions were involved. Well, this is reported in 2015 SCC Online Uttarakhand 2109. I have given my length print a copy. Well, as we please have a look at paragraph 3. By means of the present, your lordships have the judgment?
Yes.
By means of the present writ petitioners, the petitioners seek following reliefs amongst others. Issue a writ, order or direction in the nature of mandamus directing the State Government Excise Commissioner to lay down detailed mechanism pertaining to procurement of foreign liquor at all levels in the value chain so as to address amongst others all the issues raised in ground D. Well, these were issues of arbitrariness. Without troubling your lordship more with the prayers, will you please come to paragraph 7. Learned Senior Counsel appearing on behalf of the petitioner submitted that respond numbers 1 to 3, whilst placing orders on the suppliers and acting on their own whims and fancies, which has resulted in discrimination amongst suppliers, distortion of the consumer choice, and favoritism by the distortion of consumer choice and favoritism by the respond number 1 of certain brands of IMFL over the IMFL brands supplied by the petitioners, irrespective of the demand of the petitioners' IMFL brands in the market. It is also submitted that the arbitrary and illegal acts of the respond number 1 have resulted in the market sales of the petitioners' IMFL brands dropping, but I shall not trouble your lordship with the figures. This establishes that the respondent number 1 is favoring and promoting IMFL brands with lower demand as compared to IMFL brands of the petitioners. It is submitted that such arbitrary and illegal acts of the respondent number 1 have been possible on account of lack of express guidelines by the state government and the Excise Commissioner on certain specific issues, such as, well, these are the same issues that we are concerned with here, how the minimum stocks brand-wise have to be ascertained, time period within which the minimum stocks should be replenished, process for placing brand-wise orders by the retailer, reflective of actual demand and absence of mechanism for suppliers and retailers to check the availability of stock brand-wise at the warehouse of the respond numbers 1 to 3. In a representation filed before the Chief Secretary Uttarakhand, petitioners and other multinational companies through the Confederation of Indian Alcoholic Beverages Companies have highlighted the points that the existing rules do not provide for sufficient checks and balances for the respond number 1 to follow a consistent procurement or supply policy and allows it to act arbitrarily. It was brought to the notice of the Chief Secretary that the respond number 1 was releasing orders for IMFL to some companies while the other reputed suppliers were not being issued any orders for IMFL, leading to discriminatory practices and apprehensions on the transparency of process. It is also submitted that the respond number 1 has favored certain brands of IMFL to the detriment of the petitioners and certain other suppliers, completely ignoring the market demand. In the absence of a clear procurement policy, there is no clarity on the rationale for such acts. In any event, it is submitted that the respondent number 1, being a state body, cannot act in a manner which results in favoritism to some entities to the detriment of the others. The arbitrary acts of the respondent number 1 in favoring certain brands of IMFL in the absence of an illegal basis has caused grave prejudice to the petitioners. It is submitted that while the total demand in the market for IMFL has increased during the relevant period as compared to last year, the sale of the petitioners' IMFL brands has dropped significantly, and the same not only results in loss of business and revenue to the petitioners but also exposes the petitioners to the risk of erosion of established brand value. In addition to the above, it is submitted that the petitioners apprehend that its continuous absence from the market will eventually result in exclusion of the petitioner and or its brands from the market. The procurement policy adopted by the respondent number 1 is prejudicially affecting the retailers of foreign liquor. It is submitted that on account of non-supply of IMFL brands in demand, the retailers are not in a position to cater to consumer demands. The same is resulting in severe hardship to retailers in the form of loss of revenue and customer dissatisfaction. It is submitted that the failure of the aforesaid authorities to fulfill their respective duties of fixing the minimum stocks of all brands of foreign liquor that ought to be maintained by the respondent number 1 has resulted in unfettered and wide discretion being vested in the respondent number 1 to 3. Lastly, it is submitted that vesting such wide and unfettered discretion has already resulted in favoritism and the respondent number 1 acting in arbitrary and whimsical manner to the prejudice of certain suppliers. Then, my lord, the principles of law, my lord, which we have been arguing for your lordships, are, my lord, discussed. Your lordships will thereafter please have a look at paragraph 15. My lord, because the challenge was to the policy. And says the policy did not, my lord, establish checks and balances or lay down proper guidelines, did not provide for transparency. The word policy, according to Black's Law Dictionary, has been defined as the general principles by which the government is guided in its management of public affairs. It is strike law that a court of law is not expected to propel into the uncharted ocean of the state's policies. The state has the power to frame and reframe, change and rechange, adjust and readjust policy which cannot be declared as illegal or arbitrary on the ground that the earlier policy was better and suited to the prevailing situations. The state has allowed wholesale licenses of liquor. Although according to Article 47, the state has a power to completely prohibit manufacture, sale, possession, distribution and consumption of liquor, and consequently it is the privilege of the state to decide which liquor policy it decides to continue. The state has exclusive right or privilege in respect of potable liquor. A citizen has no fundamental right to trade or business in liquor as a beverage. State can therefore, my lord, here is where we come in. State can therefore completely prohibit trade or business in potable liquor. The state can also create a monopoly in itself for the trade of or business in such liquor. The state can also impose restrictions and limitations on the trade and business of such liquor. In the instant case, the state has permitted wholesale trading of liquor. When the state has permitted such trading of liquor, the question is, can it be done arbitrarily? Well, this is the question that really concerns us. But at policy, it says when the state has permitted such trading of liquor, the question is whether it can be done arbitrarily. Law is well settled that the exercise of statutory discretion must be based on reasonable grounds and cannot lapse into arbitrariness. It is true that no citizen has a legal right to claim a license as a matter of right. They cannot enter into a relationship by arbitrarily charging any person they like or discriminate between persons similarly circumscribed. The state cannot escape the rigor of Article 14 in the sense that it cannot act arbitrarily. In the instant case, although the petitioners have not pointed out the name of the company against whom they are being discriminated, as pointed out by the learned senior counsel for the respondents 1 to 3, nevertheless, the fact remains that the sales of the petitioners had drastically dropped despite there being no consumption or supply related orders. Retailers are also facing grave hardship as they are not in a position to cater to the consumer demands, resulting in significant drop in sales. The respondent number 1, it is alleged, has acted in a completely non-transparent manner, which in turn is to the detriment of the suppliers like petitioners and others. The Uttarakhand Agricultural Produce Marketing Board, as a matter of policy, will procure all brands in each FL2 and will authorize GMVN and KMVN to operate sub FL2 in all districts of Garhwal and Kumar divisions. As per the policy, opened in each district will ensure the availability of all brands of foreign liquor. To control illegal sale or smuggling of liquor, only foreign liquor in bottles with approved holograms by the excise department will be permitted for sale, and the foreign liquor will be sold at the price fixed, number of retailers, etc. Well, then this is the guideline laid down. Then it's paragraph 17. This court has already observed, while dealing with the interim relief applications on such and such, that a writ could be filed under Article 226 of the Constitution for the enforcement of any of the rights conferred by Part 3 or for any other purpose. If something is manifestly arbitrary, it is unreasonable. The government company is expected to act bona fide and with responsibility, and it will not be correct to contend that the government agency is interested only in a particular manufacturer. It is not every fancied possibility of discrimination, but the real risk of discrimination that the court must take into account. Well, this is where we come in. And then there are certain figures that I want to ultimately put forward before the court. Then paragraph 21. In the stay vacating applications which have been filed on behalf of the respondent numbers 1 to 3, respondents have repeated those averments which have largely been attended by this court while disposing of interim stay applications. Well, these are, my lord, ultimately the interim directions that the court had given to ensure that, my lord, there is no discrimination. Then paragraph 22. In such circumstance, when the discrimination is writ large on its face, why should the court not interfere and why should the court say that the writ petitions are not maintainable? My lord, on this basis, the court went on to ultimately dispose of the writ petitions. My lord, all that I want to submit, my lord, here, my lord, it is a similar situation. Well, there, my lord, the discrimination had already taken place. Well, we have burnt our fingers earlier, my lord, in other states. Well, here when the policy came forward, I came forward before this court to show as to how, my lord, in the light of, my lord, the policy that is now framed, well, there is, my lord, an inherent possibility of my being discriminated against, and that has already come to light, my lord, in the course of conduct of, my lord, the CBW. My lord, we have therefore said that, my lord, it is one aspect is pricing. Two is, my lord, my brand availability. Three is, my lord, my brand presence in the hands of the consumers. Four is, my lord, erosion of value. Five is, my lord, ultimately, my lord, the possibility of the upstream and downstream suppliers ganging up together to destroy my brand in the market altogether. And, my lord, unfortunately, there is no manner of check or balance that is provided in the policy. My lord, this, my lord, thereafter, my lord, also you will see, well, lord, there is a second judgment, my lord, also in similar lines. Well, lord, this is the case of Pernod Ricard. And I shall give my infant a copy.
Thank you. No state, you scoured the country.
No, that's it. I found out the state.
You scoured the country.
Well, can you see paragraph 2, petitioner's case? This is at page 3 of my lord, the report. Well, this is what the case was. To substantiate the aforesaid reliefs, it is the case of the petitioners that they are renowned and reputed leading manufacturers and sellers of foreign liquor in India. Their brands include McDowell's No. 1 Whiskey, Royal Challenge Whiskey, Black Dog Whiskey, Signature Whiskey, Bagpiper Whiskey, Smirnoff, Black and White Scotch, etc. They were selling foreign liquor in the state in the previous years also. Prior to 1st April 2017, retail outlets for liquor were privately owned and operated. However, on and from 1st of April 2017, control and operation of all retail outlets of liquor was taken over by the respondent number 3, and pursuant to the aforesaid change in policy, petitioner numbers 1 entered into an agreement on 16th March with the respondent number 4 for sale of foreign liquor. Since the agreement was valid up to 31st March 2018, a new agreement has been entered into between the aforesaid parties for sale of foreign liquor. It is the further case of the petitioners that prior to introduction of respondent number 3 as exclusive licensee for retail sale in the state of Chhattisgarh, on and from 1st April 2017, there was significant demand for the petitioner number 1's products, which enjoyed significant market share. There has been a drastic and significant fall in the share of petitioner number 1's products in the financial year 2017-18. Now, if you will kindly skip over a few bullet lines and come to the last 10th line from the bottom. It is pointed out, it is the pointed stand of the petitioners that the aforesaid fall in the petitioner number 1 sales has been caused by the discriminatory practices adopted by the respondent numbers 2 and 3 in the process of procurement of liquor from the respondent number 4 for the purpose of retail sales at the retail outlets across the state of Chhattisgarh. And such discriminatory practices are being followed as neither the Chhattisgarh excise settlement and licenses for retail sale, that is the liquor rules of 2017, nor the annual excise policy framed by the respondents provide for the manner or basis on which respondent numbers 2 and 3 are to raise demands on respondent number 4 for various products of various suppliers. So, there was no policy here also. Then we'll kindly see as the rules, as the rules and excise policy are completely silent as to how the quantities to be ordered from respondent number 4 are to be determined. There is no system in place whereby the manufacturers and suppliers can track or trace the actual stocks of the respective products available at the various retail outlets of respondent number 3 for purchase by the consumers. Such opacity in the system, coupled with unbridled and untrammeled discretion confirmed of the respondent numbers 2 and 3 in the manner of procurement of liquor, has made the entire process of procurement of liquor both unfair and non-transparent. Making the data in support of the case, the petitioner sought the above reliefs in the present petition. It is further pleaded that the officers respondent number 2 have been given additional charge and were posted with the respondent number 3 as they are working as regulators as well as they themselves are involved in the sale of liquor. Well, this is also a case upstream, downstream. There is conflict of interest between the respondent numbers 2 and 3, and their working suffers from doctrine of bias and conflict of interest. Then if your lordship will kindly, well, at next, have a look at
the nature and extent of loss you have indicated in sufficient detail yesterday. What would be the...
Well, here, the first question that the court had called upon me to answer is, what is your prejudice? I had cited judgments to show that, my lord, my prejudice may not be immediate. My prejudice may be an apprehended prejudice, which is, my lord, apparent from, my lord, the absence of checks and balances in the legislation.
Yes.
And, my lord, that is, my lord, also now established law. My lord, I had, upon satisfying the court had thereafter proceeded to, my lord, allow me leave of audience. So, my lord, it is, my lord, this is what has actually happened in the states of Chhattisgarh, my lord, in the other judgment that I had cited before, your lordship. My lord, today, my lord,
Number one, the demand might fall, and because of the rise in the index price or something that...
and exactly the similar situations, my lord, because of such legislations where there was no, my lord, check and balance, there was untrammeled discretion, my lord, untrammeled powers. My lord, this is what had happened in these, my lord, other states. My lord, please have a look at paragraph 42 now, 41 now.
And your business may be affected because you may be compelled to manufacture only a certain type of liquor.
Well, the challenge is
and not respond to the market demand.
Well, first of all, my challenge is the constitution challenge. You can't create a monopoly. Secondly, my lord, the policy that you frame is so opaque, it is so non-transparent, it does not create, my lord, the checks and balances. It, my lord, leaves, my lord, complete play in the joints, my lord, for creating any kind of, my lord, market, my lord, distortion, that ultimately this cannot be allowed to survive. And third, of course, is, my lord, when we talk about arbitrariness, my lord, section 19, my lord, which is, my lord, provided in the statute, which allows for exclusive privilege only in the case of intoxicating liquor and, my lord, country liquor. When you ultimately try to, my lord, do away with that, but when you are acting arbitrarily, it's arbitrary, my lord, arbitrary implementation of the statutory provision, and, my lord, that is also in itself arbitrary. My lord, that is the point of statutory ultra-vires that I had, my lord, ultimately, my lord, argued. My lord, please see paragraphs 40 and 41 and 42. Internal page 29. Thus, it is the clear case of the petitioners that on account of lack of objective criteria for determination of orders to be placed on respond number 3, the respond number 3 has been loaded with unbridled and unfettered power for making and placing orders. This is also our case. The question for consideration would be, paragraph 42. 41, my lord, is the case, my lord, made out. So on the basis of that case, the question for consideration would be whether there is an objective criteria or policy laid down particularly by the state government for placing orders by the respond number 2, 3 on the respond number 4. And thereafter, my lord, so far as these questions are concerned, but please now have a look at paragraph 52. Or paragraph 50. Paragraph 50, my lord. In sum and substance, the stand of the respond number 3 regarding the basis on which quantities are to be procured has been constantly changed during the course of these proceedings. Well, that is what the court takes note of. Paragraph 51. It is therefore quite vivid from the aforesaid stand that there is no clear-cut policy governing procurement of liquor particularly framed and brought out by the state government either under the rules of 2017 and the policy made thereafter to govern the sale of liquor while handing over the task to the respond number 3. And then paragraph 52. Now the next question for consideration would be whether in the absence of policy the court can step in and direct for framing of policy, as framing of policy is the domain of the executive and it is for the executive to frame a policy and to follow the same, and legal position is fairly well settled. Then there is discussion on this. Of course the court can strike down the policy, perhaps not make a new policy. And then your lordships will see paragraph 57. Reference is made to the Uttarakhand judgment which I showed to your lordships. Well, I shall not trouble your lordship with that because
these are very verbose, repetitive. The main point is Article 19, number 1 proviso, monopoly. Then Article 19, unreasonableness. Read with Article 14, arbitrariness.
That's right.
Right?
That's
And then Article 19 is loss of business. How? If there were a multiplicity of these boards, you could have a free market of
That's it.
demand and sale. This you have restricted, and your pricing is also becomes flexible, as a result of which your demand might go down, and consumer preference.
Yes.
Yes. This is
Yes, my lord. Free play disturbed, and my lord, all of this. I've my lord, made my submissions in this regard. My lord, these are the two judgments, my lord, that deal with, my lord, these issues, my lord, in the matter of liquor trade. One is Chhattisgarh, one is Uttarakhand, which I have shown to your lordships. And my lord, so far as general proposition is concerned, on arbitrariness, my lord, K.K. Narula's judgment, which has been cited, my lord, in the Kerala Bar Association and Coded Distilleries, my lord, case. But I just want to show you, lordships, two times.
The price would go up, the demand would fall.
Yes, my lord. Various factors, price being one of them, market presence being the other, my lord, the free play in the market being disturbed, upstream, downstream, all the points are there.
Yes.
My lord, just on, my lord, how arbitrary, my lord, now transcends just one more judgment. My lord, this is, my lord, the Supreme Court case of K.K. Narula, which dealt with the matter of liquor trade. Just two paragraphs I want to show and close my arguments. My lord, this is, my lord, reported in 1967. Well, the reason I show this to your lordship is this is a 5-judge constitution bench. 1967 Supreme Court SCC Online, SC 125. Also reported in All India Report of 1967 Supreme Court 1368. 3 paragraphs, paragraphs 11, 13 and 14. Well, this talks about the interplay of 14 and 19. That's why I want to show this to your lordships. Paragraph 11 first, a combined reading of clauses 1 and 6 of Article 19 makes it clear that a citizen has a fundamental right to carry on any trade or business, and the state can make a law imposing reasonable restrictions on the said right in the interests of general public. It is therefore obvious that unless dealing in liquor is not trade or business, a citizen has a fundamental right to deal in that commodity. The learned Advocate General contended that the dealing in liquor was not business or trade, as the dealing in noxious and dangerous goods like liquor was dangerous to the community and subservive of its morals. The acceptance of this broad argument involves the position that the meaning of the particular point of time in our country. Such an approach leads general acceptance of the standards of morality obtaining at a particular point of time in our country. Such an approach leads to incoherence and thought and expression. Standards of morality can afford a guidance to impose restrictions but cannot limit the scope of the right. So too, a legislature can impose restrictions on or even prohibit the carrying on of a particular trade or business, and the court, having regard to the circumstances obtaining at a particular time or place, may hold the restrictions or prohibitions reasonable. The question therefore is, what is trade and business? Though the word business is ordinarily more comprehensive than the word trade, one is used as synonymous with the other. It is not necessary to bring out the finer points of distinction between the two concepts in this case. In the words of S.R. Das, J. as he then was, the word business connotes some real, substantial, systematic or organized course of activity or conduct with set purpose. Even accepting this test that the activity of a dealer, say in ghee, is business, then how does it cease to be business if it isn't liquor? Liquor can be manufactured or brought or sold like any other commodity. It is consumed throughout the world, though some countries restrict or prohibit the same on economic or moral grounds. The morality or otherwise of a deal does not affect the quality of the activity, though it may be a ground for imposing a restriction on the said activity. The illegality of an activity does not affect the character of the activity, but operates as a restriction on it. If a law prohibits dealing in liquor, the dealing does not cease to be business, but the said law imposes a restriction on the said dealing. But it is said that the decisions of the court have held that dealing in liquor is not a business or trade within the meaning of Article 19. Then, a reference is made to judgments. Then you will find that, the last paragraph in the page. This court did not say that there was no fundamental right to do business, but only held that a citizen could claim that his fundamental right could not be restricted in public interest. Nor did the decision of Kuvarji and the Chief Commissioner laid down such a proposition. There the question was whether excise regulation imposed a reasonable restriction within the meaning of Article 19(6) of the Constitution on the right given under Article 19(1)(q) thereof to carry on business in intoxicating liquors. Then your Lordship will kindly come to paragraph 13. Two small paragraphs now. Scrutiny of these decisions does not support the contention that the courts held that dealing in liquor was not business or trade. They were only considering the provisions of various acts which confer a restricted right to do business. None of them held that the right to do business in liquor was not a fundamental right. We therefore hold that dealing in liquor is business and the citizen has a right to do business in that commodity, but the state can make a law imposing reasonable restrictions on the said right in public interest. Well, the question, my lord, therefore is, my lord, whether the restrictions that are now placed or sought to be placed by appointing the central bonded warehouse as the sole agency for, my lord, ultimately sourcing liquor into the state and thereafter, my lord, distributing liquor to the bonded warehouses is a reasonable policy. My lord, now in the course of interactions with this court in this matter, the state, my lord, went on to admit that yes, there is a problem and proposed the appointment of a second CBW, which of course was opposed by the third respondent CBW appointed in the matter. Well, that is recorded in the orders which I have already placed. Well, these are my respectful submissions. Why I say that ultimately, my lord, on the constitutional challenge brought to, my lord, these amendments, well, this has to be struck down. These are my respectful submissions.
Thank you very much, Mr. Grateful. Mr. Banerjee, 7th, 8th, 9th.
I believe the bonded warehouse.
Well, we are there in the next matter, item number 10. Well, it's again, this time for the bonders. Well, it's the bonders are before your lordship.
Arguments are same. So
more or less, well, I'll be adopting the arguments led by my learned senior. Of course, a few issues, well,
How much time you are likely to take, Mr. Paul?
About half an hour, not more than that.
Mr. Banerjee, you are here tomorrow?
No. I can wait half an hour, but that's for your lordship, or he can come on the 7th and do it, whichever your lordship likes. I mean, up to your lordship.
Mr. Jishnu Sir, learned senior advocate appearing for the appellant. In so-and-so appeal.
I had suggested earlier in the morning when it was called. Rather than I'll take all 3 days.
Mr. K. Paul, learned senior advocate appearing for the appellant.
Put you in embarrassment. But you please join us.
In the connected appeal, so-and-so shall commence his arguments on the next dates fixed for hearing of these appeals. List these appeals for continuous hearing on 7th, 8th and 9th May.
Your lordship will give us permission to appear virtually, since we don't have to address
Yes.
I have similar prayer. I'm appearing for respondent number 3.
Central bonded warehouse.
Central bonded warehouse.
CBW.
Let him first complete, then we will give you leave.
No, that I'm not saying that. What I'm saying that my learned friend is going to take 7, 8, 9, as he said.
Yes.
So those 7, 8, 9, if your lordship permit me, I can join virtual online.
Yes.
Both Mr. Shah and my learned friend both will join online. Everybody.
So for continuous hearing on 7th, 8th, 9th.
Yeah, I will take more than 3 days. He has taken 7 days. I shouldn't say 7 days, 7 sessions would be fair.
Apart from Mr. Paul and Mr. Banerjee, the other learned counsel may join the hearing virtually.
I'm DK Mishra. My name is DK Mishra.
Yes, I said apart from Mr. Banerjee and Mr. Paul, other learned counsel, including Mr. Shah and Mr. DK Mishra. So may join on.
All right.
Great.
Let him rise, brother. Oh, one more matter, sorry. I understood. He's going to take
All matter.
Item number 3 and 4.
What is?
Hearing is nearly complete.
Have you fixed any matter tomorrow?
Issue an affidavit was needed. We filed it only on the technical and well-factual.
Contempt. One contempt.
We may now.
Well, subject to your lordship's convenience, Now the matter can be fixed on the 20th if your lordship feels, because learned senior is coming from outside.
28.
No, you start today, why 28?
Yes, Your Lordship.
I'm ready.
Start today, continue tomorrow.
Tomorrow I have some difficulty, my lord.
Then
No, Lordship.
you just spare one after half a day, then
Actually, after the writ appeal has been dealt with before this honorable bench, my lord, there have been fresh affidavits exchanged by the parties. So there are certain factual aspects of the matter, my lord, which I need to highlight. Because that has come from the affidavit of the state as well as the other appellant.
your learned friend there is very keen on early disposal of the matter, which makes the court also a little
My lord, may kindly,
about it.
my lord may kindly also consider one aspect, my lord. All throughout the proceeding before the learned single judge, they remained as a fence sitter. Now, the moment, my lord, the judgment has come, that they have jumped up with all eagerness to have the matter decided within a day or two. My lord, that is perhaps not, my lord, reasonable in the.
That is why, Lordship, all along I have been quiet.
This country is full of fence sitters. 99.9% are all fence sitters. So what do we do?
Lordship, I fix it tomorrow, Lordship.
Well, tomorrow I have some difficulty, my lord. I could have otherwise, my lord.
Who's for the appellant?
I am the respondent.
And myself, Lordship.
I am the respondent and in whose favor.
When you start, let us see for 5 minutes, then we will see.
Lordship.
Yes.
Okay, that's it. It's already the major part have been completed. Only on the technical para 11 of the judgment.
Yes, you start.
I'll assist with footnotes.
Just tell us what is the issue involved, what is the judgment.
Yes,
under
my
appeal.
lords. So the issue, my lords, here concerns, my lords, a tender for construction of a indoor stadium. My lords, in the bids were issued, my lords, and there was a minimum price which was fixed in the tender itself. And it was specifically stipulated that if you quote the price below this amount, then your bid would be considered as non-responsive, it would not be accepted. 5 bidders participated. Out of the 5 bidders, 4 of the bidders submitted the minimum price which was quoted in the notice inviting tender. The respondent quoted 1 rupee 37 paisa more than the reserved price. And based upon that, the respondent instituted the writ petition before the learned single judge.
No, the contract was awarded in whose favor?
Contract was awarded, my lords, in favor of one of the bidders who had quoted the reserved price. All the bidders who had quoted the reserved price were called for a meeting. There were 4 bidders who had quoted the reserved price.
He was not called?
He was not called because he was not the L1 bidder. He was not the L1 bidder. So 4 bidders were called, my lords, and in that meeting, 3 of them chose not to pursue with the matter. So 1 of them remained, and my friend is representing that the successful bidder. So the successful.
So where did he come in, Mr. Sengupta?
The respondent challenged the award or work order, which was.
Yes.
So the respondent was challenged the work order, saying that he should have been considered. He should have been considered in the process of selecting the successful bidder, even though he had not quoted the lowest price, which was there. So based upon that, a writ petition was instituted, and allegations were made that
I think
cartelization. But the difficulty with cartelization, Milords, is that cartelization should lead to certain appreciable benefit to the members who are cartelizing. Here, the people are quoting the minimum price available. So there is no benefit that anybody would get out of cartelization, even though if his argument is considered to be correct. So one of the arguments which was made was cartelization, and secondly, the respondent had insisted that because there were identical bids, there has to be technical evaluation of that bid, even though the technical evaluation stage had crossed and we reached the stage of financial evaluation. At that stage, the learned single judge had passed the impugned judgment
presumably on the understanding that there was no technical evaluation at all. Whereupon your lordships are by the virtue of the order dated 6th February 2025 direct.
They were disqualified on the ground of technical incompetence or on the ground of higher
bid. Because they were not taken into consideration for selection as a successful bidder because their bid was higher than the others.
In the financial stage.
In the financial stage.
And in the technical stage, they had qualified.
They had qualified and remaining other people had also qualified. Now, your lordship had asked us to place an affidavit showing whether technical evaluation was at all done or not. We have placed that affidavit with the memo minutes of meeting showing that.
Why should we do it? Because the technical thing would have been they had qualified in the technical.
Yes.
Then why was that occasion?
Because the contention of the respondent was that there was no technical evaluation done at all, and we directly reached to the financial evaluation in the tender evaluation process.
Even in the judgment, it is shown.
So, and even the
one was they were not technically qualified.
Yes.
Even if financially their bid was the lowest.
Right.
Single judge came.
So the learned single judge also had passed the impugned judgment on the premise that there was no technical evaluation done, which, my lords, has been countered by the minutes of meeting.
So 2 points are there: technical qualification and authorization.
Yes.
That's all.
Yes.
When do we get the appeal? Yes, Mr. Datto.
He was suggesting 20th of May.
That's too far away. 20th of May.
My lords, may then consider subject to learned seniors availability on
15th or 16th of May.
Well, you are going abroad or what?
No, my lord. Some my lord, matters are also.
No, you should have consent for the court. We will forget everything.
Or any day in the first 6th, huh? 7th of April. But then, if you are saying
primarily you practice in Meghalaya High Court or Guwahati High Court?
Guwahati High Court. 7th of May, the other matters, the bonded warehouse matters, your lordships have fixed up on those dates, 7th, 8th and 9th. So that's why, my lord, I just wanted to avoid collision with that matter.
6th of May, you come and do the matter.
6th of May, okay.
Lordship, I pray Lordship, let it be on after 20th of May, Lordship. No other way, because I have been, for this case, I have been stuck, Lordship, yeah.
No, you are.
That Lordship may fix in coming week, Lordship. We can complete it. Tomorrow it was okay for me.
You do not reside in Shillong?
No, Lordship, I am also from Guwahati.
You come on 3rd May.
3rd is Saturday, Lordship.
The matter is being fixed on 6th. Come on,
6th is fine, my lord. 6th is fine.
6th.
Why don't you do this matter online, but finish it? If you want to do it online. We are giving you leave.
On 9th.
9th, Mr. Banerjee's matter is there.
So that's why 6th is otherwise convenient, my lord.
Yes.
Online.
Online, Lordship?
Yes. Because no use dragging you from there and then the matter not being taken up.
Lordship.
All right. Considering the convenience of the court as well as that of learned counsel, list this appeal for final disposal. No, for hearing on 6th May.
Lordship, we can come to Vice.
To be heard virtually at a time to be notified by the registrar listing. In the list to be published for that day.
Obliged, Lordship.
Obliged.